Hello, everyone, and thank you all so much for joining us on our weekly webinar. Today, I am joined by our awesome managing attorney, Ruby Powers, and we are here to discuss criminal records and how they can affect your immigration case. Just some quick background info on our attorney Powers. She has been licensed since 2008 and founded her firm back in 2009. She is also a board certified immigration and nationality attorney. Attorney Powers, do you want to go ahead and take it away?
Yeah, sure. So, this is a hot topic. A lot of people, I was actually just talking to a friend about this yesterday evening for one of her employees. And, I feel like we did talk a lot about this last week about the impact of marijuana as well. But basically, there's criminal law and there's immigration. And when you put it together, we call it crimmigration. And crimmigration really means the analysis and review of what are the consequences of certain crimes on a person's immigration status. And not every immigration attorney does this. Not everyone has a lot of experience in it. And so when you have a more complex crime, you want to make sure that the attorney that you're working with, understands this nature of the subsection of immigration. That's really important because there's a lot of misunderstandings and things change over time. And the other thing that I see, it's a common trend, is that criminal defense attorneys might not know very often they don't know the immigration consequences, which is why they need the immigration attorney. But I'm not a criminal defense attorney. So it's like I need to know enough of the crossover to give guidance to my client. But a lot of times what happens in this space, if it's not one of the more run-of-the-mill misdemeanor or crimes that we generally see, then we would need to team up with the criminal defense attorney in the locale of where the crime occurred and where you're trying to have the case resolved. The other thing that can be complicated is that maybe your immigration attorney is familiar with Texas crimes and statutes, but the crime happened in Florida or California or what have you, or another country. And so sometimes you have to team up with another attorney and sort of like bridge that gap. So our overview is just basically, why is this even a conversation? Well, because there's a lot of misunderstandings. And a lot of times people think that if a crime happened and they get dismissed, that it doesn't exist, or they get expunged, it doesn't exist. They think all these things, and those are not true. So it's really important that if you've ever been convicted of a crime, or it is deemed as a conviction for immigration purposes, which has its own definition, that you have to announce this for when you're applying for any immigration benefit in the U.S. and for a non-immigrant or an immigrant visa. And the other thing to note is that even if something has been dismissed, it still can be a conviction for immigration purposes. Even if it was expunged, it still exists, and it still can be a conviction for immigration purposes. And so these can have a lot of varying consequences. It could keep you from being able to come into the United States. It could keep you from keeping your legal permanent residency status. It could lead to a deportation order. And so there's lots of different consequences. And so the other one that's really detrimental is when legal permanent residents have a crime, they travel and they come back, and then they're deemed mandatory detained and put in immigration proceedings and have to fight for their green card and their chance to stay here in the country. So we'll move on to the next slide. So does a criminal record affect my application? Well, yeah, almost always it does. You have to sit down, you have to analyze it and see, does this have, it affects it because it exists. And so when it exists, you have to mention it somewhere. Even if it doesn't have a consequence, you still need to mention it. If you're silent about it, then that would be considered misrepresentation, arguably because you are not telling the truth. And that's why you need to be able to mention it. Sometimes people forget about things that happened a long time ago. or sometimes people don't want to remember things, or sometimes people are filling things out for someone else and they don't know about it. And so that's why it's really important. So they need to make sure it's all about what we call like inadmissibility. It's like I joke when I'm teaching with some law students, like the US is sort of screening you. It's like there's this like laser, they're screening you and they're analyzing, are you a good person? Do we want to let you in? And they're going up and down and they're sort of like, do you have any inadmissibilities? And so when they're screening you and you have something, then they have to see what the consequences are for what you're trying to do. So that's where it can get complicated. So you need to list any incidents you had. Not every criminal offense will negatively affect your green card or your non-immigrant visa or what have you, but they have different consequences. For example, a DACA, right? We love and know DACA. It's about to turn 10 soon. And if you have a DWI, that makes you ineligible. But if you have a public intoxication, you still could be eligible. If you have any serious misdemeanors, that could kick you out of the running for DACA, for example. So that's why it's important, and it can relate to that specific thing that you're trying to accomplish. So usually there's non-immigrant visas. People are applying to come in on student, tourist, employment-based, investment visas. And then there's these other types of categories like DACA, temporary protected status. Temporary protected status also has provisions where you're not supposed to have too many misdemeanors or you could be ineligible. And then there's the green card. And that has its own particular set of rules of how many crimes or what type of crimes you're allowed to have. So the other thing is that if anything is deemed an aggravated felony, which is clarified in the INA, you're going to have a lot of problems. It's very clear about what's considered an aggravated felony, and you're pretty much ineligible for most things, except for very few things. If you're deemed to have an aggravated felony, illegal drug involvement can very, very problematic. There's only a couple of waiver situations. And it depends on the volume, how much, and when it happened. That's the other thing. This gets complicated because the law changed in around 96 and 97 when the IRA, and everything got a lot more complex. And so that's why when somebody's reviewing your record, you can't just tell them, well, I got this something. No. We need to see the piece of paper. We need to see the actual conviction as much as possible so we can read it and analyze it. And we're detectives, so we, in a way, so we're going to analyze that for every little aspect of information. And then crimes involving moral turpitude. So moral turpitude is like, like moral badness, I guess you could say. And so if it's deemed that you have a dishonest person, badness at heart, I guess you could say, then if it's a crime that's been deemed that in case law, then that's going to give you some more problems. Generally, you're allowed there's a petty offense exception that allows you to get away with one crime that could normally give you a problem because they want to give you like one little opportunity. But if it's bigger than that qualification, then you're going to be in trouble, and you're going to have to see if you qualify for a waiver. But again, it's really important to talk about what are you applying for, and what are the requirements of that, because sometimes it can be confusing because I might be mixing some concepts around, and that is true. It can seem confusing, but it's really important to, first of all, find someone who can help you analyze it and be clear as to what you are trying to apply for, and then find out what the consequences of that crime on what you're applying for. So that's basically the crux of the case of what we're talking about. So let's move on to the next slide. And what I was and the other thing that makes all of this a little bit more complicated too is that the case law is always changing. And so if you have a very complex case, you're going to really want to talk to somebody who who reviews the criminal laws, case law on a regular basis, and can let you know what the consequences are of that matter, and your that circuit that you're located at that time. Okay, so let's move on to, does the USCIS check your criminal record? Well, yeah, they do. So it's not just USCIS, it's the Department of State has you review send you the criminal records or your police clearance records for anywhere that for immigrant purposes, immigrant visa, they make you send a police clearance record letter for everywhere you've lived for 6 months or more. I believe it's after the age of 18. So that's sort of their way of creating your background check. For non-immigrant visas, they're asking you if you have any crimes, and they're going to ask for a copy of it if you have any. And if you're applying for an immigrant visa, they are going to, and inside the country, they're going to check your record by doing your biometrics and run that record. Now, sometimes when they run records, they're going to find things that might be wrong. I've done many a FBI background check, and I found things that still existed even though they were expunged or were incorrect in the record. So it's your burden to prove what's going on, and you need to have records of anything that's ever happened. Even the consult I had earlier today, they had an old record from something and just one piece of paper. But what you really need is, that usually it's the charging document, the resolution, like if there was any probation, any fees paid. You need it as much as possible, even if you can get police reports just so that we can know what happened, even though that's generally not what we have to submit. So there are, here in the US with USCIS, they have their database, and they check that by having you do biometrics. And they used to make you physically go do your fingerprints on it every once in a while to run it. But now they realize there's technology. And so once they have a copy of your fingerprints, they can just run it every once in a while whenever needed. So a lot of times they're not making you do them again. So let's move on to the next slide. So they do check your record. So let's say that you're, and we're talking a lot about a lot of different things here: non-immigrant visas, immigrant visas, and we're also talking about like some other statuses like TPS and DACA. But once you figure out what the crime is, you look at it, you try to analyze what are the immigration consequences for what your current status is and the status that you want to have. And it could be, if you meet the petty offense exception, we were talking about that if it's more of a small crime, it could meet the petty offense exception. If it was deemed a juvenile record, it doesn't exist for conviction purposes if it was truly as a juvenile, in most cases. And so there's some things that you have to analyze, all those things. But let's say that it's something serious and you're going to need a waiver for it. So there's two types of potential waivers. One of them is for the immigrant visa, immigrant status, legal permanent residency. And so that form is I-601. And that would be the form you would have to fill out. Now, if you take a look at it, it has a lot of things that you can check off about. And we'll go into slide next about it. But then if you're talking about a non-immigrant waiver, that would be 212D3. So the 212D3 is the serious three-pronged test, matter of Harinka, and it says, what's the reason for that three things. One, basically, how bad was the thing you did? How serious is it? Two, what's the purpose of why you want to come here for that tourist visa, employment visa? And three, are you a public safety risk? So, for example, if we have an L1 employee and he's wanting to come here to the United States, but he had a DWI in the past, they could tell that you need a 212D3 waiver for that, and then you have to explain what happened and say that that's not going to be a public concern anymore, and the seriousness of that. Then maybe it was a long time ago, so you try to meet those qualifications. So let's go to the next slide and talk a little bit more about the I-601. So basically, I-601 is used for lots of different things, but if we're just talking about crimes, let's say that you can meet the qualification for this crime. So you need to have a U.S. citizen or legal permanent resident, spouse, parent, or child. You could also have a U.S. citizen fiance, and you have to be able to explain the hardship, which is things like to them, the qualifying relative. So would they be able to relocate for you? So this is the immigrant waiver, right? And let's say you're applying for a green card and you need the immigrant waiver to overcome that crime. Is there anything else going on in the country that you're from? Would you be able to relocate? Are there certain health, medical issues, financial issues? And so you really talk about that hardship to those qualifying relatives and why they can't relocate to be with you and why they can't live without you. And so those are the things that you would be putting together. Now, this is for an immigrant waiver. So I-601s can be also used for misrepresentation, fraud, unlawful presence, and some other things like that. So don't get confused, because it depends. That form can have different qualifying relatives for the different inadmissibilities. But just specifically for what we're talking about right now is crimes. And not all crimes can be overcome. So like we talked a lot last week about like marijuana, for example. If it was more than 30 grams of marijuana, then there isn't a waiver for that. And so those are things to consider. But if it was 30 grams or less, then this waiver would help you overcome that if you're applying to be a green card holder, for example. So let's move on to the next slide. So a lot of times we don't really talk about this actually. But can you sponsor someone if you have a criminal record? Well, it really depends. So a lot of times we're so focused on the beneficiary, we call it, like the person who's going to benefit from the visa or the green card, but we don't focus too much on the petitioner. But that really can matter. So USCIS doesn't, there are some crimes that can prevent the petitioner from sponsoring someone else. And they generally have something to do with offenses against minors or something sexual against minors. There's the Adam Walsh Act that generally, like if a U.S. citizen had a crime that had something to do with the Adam Walsh Act, which is pretty much sexual offense towards a minor, then that would prevent them from being able to petition for like a spouse or a parent. I don't see that very often. I think I've seen it maybe 2 or 3 times in my last 14 years as an attorney. But those can be very difficult. And so you have to be concerned, you have to be knowledgeable about that. That can happen. One time, it's not the same level of this, but I was in a green card interview, and we were in there, and then all of a sudden these like marshals came in and were like, "What's going on?" And the U.S. citizen had the petitioner had a warrant for arrest for some speeding ticket he hadn't taken care of, and so they took him away, and it all worked out in the end. But I mean, that was really scary because it was another example of how we do need to make sure we monitor the criminal record of the petitioner. And also this becomes more of an issue I see with like fiance visas too. Like they want to make sure that there is not potential abuse by the intending fiance. So they'll ask and screen for that because they want to make sure that they don't see any potential red flags. So let's move on to the next topic. But this is a concern. So it's not like any American or legal permanent resident can just petition for anybody in case there's some cases where they might be prevented to do so. And so then how do you answer these criminal history portion of the application? So this is everywhere, right? This is on the DS-160, the DS-260. This is on the I-485. There's lots of different places, and they ask it lots of different ways, right? It's like 5 different ways to ask the same question. Have you ever been arrested, cited, charged? Have you ever, been detained? Have you ever been convicted? Did you ever commit a crime? Like I think this is on the naturalization one, then 400. Have you ever committed a crime that you were not arrested or charged for? They're just covering all their bases. Basically you need to tell the truth. I think if it's confusing to answer, then you should definitely review it with an attorney who has experience, because maybe you don't understand what it's asking, and maybe it's confusing, right? If it's confusing, I think you should try to get some help to go over that and review it. Now, if you say something like, for example, for consular processing, if you say something that like leads to, if you say, yes, I have this crime, that can lead to a whole nother line of questioning. It could lead to you needing a waiver. And maybe you said yes when it really should be no. So that's why answering certain ways can lead to more scrutiny, more needing of waivers. And it's really important what you say. You might think it's just like checking off some boxes and stuff like that, but no. It's and I think, Daya, didn't we talk about this yesterday about the Supreme Court case? I think this week, about how the immigrant filed and said he checked citizen when he was trying to register to renew his driver's license or something, and then
Yeah.
that one innocent mistake led to a whole lot more problems. And so that's why it's really important to review your records and go over that closely. And I do want to mention one other thing that is very specific. And whenever I talk about immigration, crimmigration, I talk about this, but the Board of Immigration Appeals, and we can go to the next slide, but this is important to what's a conviction. So imagine this, though. Can you believe this? The Board of Immigration Appeals held that a guilty plea or finding of guilt, plus any imposition by the judge of probation, fine, jail, or even requirement to attend a class will create a conviction for immigration purposes. So what does that mean? That means, like, if there's a finding of guilt or you plead guilty and then you do any of these things like fine, jail, attend a class, probation, that still is a conviction. So there's sometimes where the deferred adjudication is still a conviction. I think pretrial diversion can depend on where it's done, whether you plead guilty. You have to meet those two prongs, which is basically, again, it's a guilty plea or finding of guilt is the first prong. And second is some type of imposition by the judge, such as probation, fine, jail, or even attending a class. So those are my usually key takeaways when I talk about crimmigration. It can be a conviction, you don't even realize it. It could be dismissed and still be a conviction. It could be expunged and still a conviction. And the consequences of that crime might be minuscule when it happened and huge 10 years later. It's really unforgiving. And usually what happens is a criminal defense attorney, but I'm sure best intentions, says just plead guilty, you'll get out, and we'll get this dismissed later or something like that. And then they're thinking, oh, I don't do much jail time, I get dismissed, it'll get expunged, and it doesn't cause problems. See it all the time. No, like I just said, it could have minuscule consequences and later on huge. And like I also said, if it gets dismissed, it could still be a conviction. If it gets expunged, it could still be a conviction. And the other thing is that maybe the criminal defense attorney doesn't talk to an immigration attorney and understand what those consequences are. I mean, honestly, it's your responsibility to seek out that information. And so that's why we're doing today's chat about this. So I hope I didn't scare you, but really this is important to know. And I mean, I think the biggest thing is I wish I could get this information out to people before they plead, before they make assumptions, before they make key decisions. And a lot of times I hear people didn't have the money, the resources to hire an attorney. They didn't know any better, and things they pled to when they were teenagers or young and misguided have consequences on their family and their future many years down the road. So that's crimmigration in a nutshell, I think, Daya. I'll stop talking there. How can people stay in touch with us?
Yes, thank you, Attorney Powers, for this great information. For you guys to stay connected with us, you can join us every Tuesday. We go live at 5 p.m. with immigration updates. And then we also do these weekly webinars. We did it at a different time today because Attorney Powers had court, but they're usually at 11 a.m. And we are also on all social medias. You guys can add us on Facebook, Twitter. We also have a newsletter that goes out bi-weekly. It went out yesterday. And we have an Instagram and a TikTok. We post a lot of good stuff on our TikTok, so I recommend you guys go check us out at Powers Immigration Lawyer. And go ahead and join us next week for our last webinar of May on latest on USCIS premium processing times. But thank you all so much for joining us today, and we hope to see you all next week.
Thanks so much.